forcefully comes onto someone else's property. The law tells us, hey, there are certain circumstances where if certain things happen, you can presume that someone has a reasonable fear. If certain things happen, you can presume that the person was going over there to cause harm. And these next two slides, they deal with that portion of the law. And we sort of have to read these in conjunction with each other, and so I want to go over the definition of dwelling. And this is something that Mr. Buxman didn't talk about, and this is really important. So dwelling means a building or conveyance of any kind, including any attached porch. Whether the building or conveyance is temporary or permanent, or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. So remember that includes any attached porch. So when we go back and we're looking at this, the person against whom the defensive force was used, aka Miss Owens, was in the process of unlawfully and forcefully entering, or had unlawfully and forcibly entered, a dwelling. So a dwelling includes an attached porch. So did Miss Owens unlawfully and forcefully step onto that porch? Absolutely. Not the door. We don't have to wait for her to get inside the actual house. The patio is part of the house. The law tells us that. So did she unlawfully go there? Absolutely, she was trespassing. Did she forcefully go onto the porch? Absolutely. How do we know that? Yariel Rodriguez, Jareth Gardner, Rosalie Smith, Yvonne Costa. She's yelling. She's angry. She's loud. She's banging. That's forcefully. That's what makes this different from someone like an Amazon driver coming to deliver a package. Miss Owens forcefully went on that attached porch, and that's the dwelling. And if that's the case, we have to presume that Susan Lorincz had a reasonable fear, because the law tells us that we have to. If that's the case, we have to presume that Miss Owens was going over there with the intent to commit an unlawful act. We have to presume that. We don't get to guess that. Well, maybe she wasn't going over there, she was just trespassing. No. The law says if she unlawfully and forcefully entered that attached porch, we have to presume she was going over there with the intent to do harm to Susan Lorincz. This slide is really important. If you find that Susan Lorincz, who because of prior threats or difficulties with Ajike Owens had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Ajike Owens, you may consider this fact in determining whether the actions of Susan Lorincz were those of a reasonable person. So let's talk about those prior incidents that we heard about. So Deputy Coleman testified. The state called him as a witness, and he told us, yeah, I went out there February of 2022. And he told us, Susan Lorincz told me that Ajike Owens had battered her with the trespassing sign, hit her in the leg. And Deputy Coleman spoke to Ajike Owens, and he told us that Miss Owens told him, my dog likes to defecate on Susan's property. That's his favorite spot, and I don't care. That's where he's going to go. And unless she can show me a deed or something other than that, that's where he's going to go. Deputy Coleman talked to Miss Owens about this interaction that she had with Susan Lorincz. And Miss Owens again told the deputy, yeah, I told her I don't care about your sign. I can go get myself a sign if I want. I don't care about it. And she admitted to Deputy Coleman, yeah, I threw the sign. Deputy Coleman told Miss Owens, look, even though she's renting, that is not public space. That is private property. You cannot go over there. If you have an issue, call us. Coleman told us that he saw a red mark on Susan's leg, but despite that, he never arrested Ajike Owens. But we heard from London Remy, though, right? She was there and she saw this. She told us. I saw the sign hit Susan's leg. I mean, it barely hit her, but it hit her. For whatever reason, deputies decided not to arrest Ajike Owens. Deputy Coleman told us that Susan Lorincz had taken a photograph of Ajike Owens when they were having this confrontation. And this was entered into evidence, and it was stipulated to that this is the photo that Susan Lorincz took of Ajike Owens on February of 2022. Now, we also heard from Shelby Kinsey, and she was another deputy that had responded out in December of 2022 because of another altercation between Ajike Owens and Susan Lorincz. And Deputy Kinsey told us, I spoke to both Susan, I spoke to a mother, didn't even get her name, but spoke to a mother. We later learned it was Miss Owens, and Miss Owens told Deputy Kinsey, yeah, my 9-year-old son was mouthing off to Susan Lorincz. Miss Lorincz had told Deputy Kinsey that Miss Owens came to her house, knocked on her door, and said, if you treat my son like this again, I'm going to rip your ass out of your house and beat you up. Again, on that night, Miss Lorincz told Miss Owens, you are trespassing. Please leave my property. But Miss Owens didn't leave again on that night. She said, I have my son here, and I'm just going to talk to you about what happened. Susan Lorincz said, get off of my property. And when she felt threatened, she called the police, and that's when Ajike Owens left. Deputy Kinsey told us that Miss Owens herself said, Susan told me I was trespassing. Leave. I didn't leave. I wanted to talk to her about what happened with her and my son. Deputy Kinsey told us that Miss Owens herself told her, I said to Susan, if you walk up on my sons again, you're going to have to deal with me. Those were Miss Owens' own words. Once again, Miss Owens wasn't arrested, and Deputy Kinsey told her, you can't go over there. If you have an issue, call us. In her statement, Susan had told detectives about another time that Miss Owens had followed her a couple months before this incident, where she was like a foot behind her and she was following her almost all the way into her house. And that's the reason why Susan Lorincz had all these no trespassing signs up, members of the jury. She just didn't want people on her property. Now, this slide and this part of the jury instruction sort of deals with that same premise of if there's prior interactions between Miss Lorincz and Miss Owens. And this talks about, if you find at the time of the alleged manslaughter by use of a firearm, Susan Lorincz knew that Ajike Owens had committed an act or acts of violence, you may consider that fact in determining whether Susan Lorincz reasonably believed it was necessary for her to use deadly force. Now, Mr. Buxman said, well, threw the sign, hit Susan Lorincz in the leg. London Remy told us that it did, but who cares? It was a flimsy little sign, no big deal. Maybe it's not a big deal to him, but it could be a big deal to Susan Lorincz as she's experiencing a traumatic situation, and it's something you have to take into account, and she knew that she had been previously battered by this woman. It was a big deal to her, to Susan, and that's what matters. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Susan Lorincz and Ajike Owens. Why does the law do that? Because it recognizes that a 35-year-old, 293-pound woman is much more dangerous if she gets her hands on a 58-year-old woman with the physical problems that Susan Lorincz had on June 2nd of 2023. Ajike Owens has much more capabilities, and Ms. Lorinc's medical records are in evidence, and you can take your time when you're deliberating and you can go through them and look at all of those things. And we heard Susan talk about all of the medical conditions that she was suffering from when she spoke to detectives about her cervical fusion and her bad knees, her knee going backward, and all of those things. The law says you have to take those things into consideration. I want to play this visualization for you one more time, but as you're watching it and as it transitions into the part where Susan Lorincz is in her home before she fires, I want you to focus on the door. Now, the state asked, I believe it was Mr. Smith, they asked Toby Terpstra, you took some liberties with making this video. That video was created based on Susan Lorinc's statement to detectives, where she told them multiple times, I saw that door coming in. I saw that door moving. She says that multiple times throughout her statement. That is what she said. So you can imagine how she sees this door moving the way that it is, and she knows that the door frame is damaged. How scary that must have been for her. And she had a split second to make a decision whether or not to fire her weapon. The state asked some of the witnesses about Susan Lorinc's demeanor after the fact. They did a pretty big deal about, she asked about her cats. They asked another witness, how did she seem? She's like, well, I mean, I don't know. Is it really that unreasonable for someone as a pet owner who has two cats to just say, hey, can you just close my door so that my cats don't run out? Because she asked that question, that must mean she wasn't in fear. And I want to address this. This is my only chance to speak with you, and Mr. Buxman may get up and speak, or he will get up and speak after me, so I want to address this just in case. In her interview, Susan Lorincz, they ask her questions about her researching Stand Your Ground. On that second interview from June 6th of 2023. But if we go back and we remember, during that June 3rd of 2023 interview, the detective says to her, the law says it has to be imminent. And he's explaining to her sort of the law, and she's like, okay. Is it reasonable for someone to leave that interview and go and research? Like, man, I wonder what the law really says about this. Is that reasonable? Absolutely. The state argues that Ms. Lorincz knew that law enforcement was on the way, but we know it took law enforcement almost 15 minutes to get there. 8:54 is when she called 911. First officer didn't respond on scene until I believe it was 9:08. A lot can happen in 15 minutes, members of the jury, when you are in fear for your life. A lot. One of the last times the police came out, when Susan Lorincz told them that she had been battered, they didn't even ask Ajike Owens her name. The state says it's only 2.5 minutes. Only 2.5 minutes have went by. But Dr. Bedard, he talked to us about that perception and how that can feel like a very, very long time. And the state introduced some videos that Susan Lorincz had taken earlier in the day, and they had introduced this umbrella, and they introduced these skates. Even Mr. Buxman in his closing admitted, like, none of that even really matters. But they took the time, they introduced those things. Why do they do that? Do these skates, the umbrella, these videos, prove to you in any way that Susan Lorincz wasn't reasonably afraid? Because remember, they have the burden to prove she wasn't acting in self-defense. During the trial, Mr. Smith made it a point to ask some of the witnesses, particularly our expert, Joshua Wright, did you see there could have been gunshot residue on the door? All the stuff about the gunshot residue. Did their crime scene tech ever test the door for gunshot residue? Did you ever hear any of that? It took law enforcement over 2 weeks to even go out and collect that door and place it into evidence. And by that time, Charles Gabbard had already got his hands on it, sanded it down, filled it in, painted it over, before they even collected the door and placed it into evidence. A door that they made it a point to ask the witnesses, was there any dents, any scratches on it? Waited 2 weeks after Charles Gabbard had done work to it to even collect it. So I want to talk to you just a little bit, and I'm almost finished, about the state's burden. And I want to show you a little bit about sort of how that means, or what that means. If you are anywhere along this chart, other than the red part at the bottom, you have to find Susan Lorincz not guilty. If you think it was self-defense beyond a reasonable doubt, she's not guilty. If you think, man, this might be self-defense, that's not guilty. Even if you think it probably wasn't self-defense, that's not enough. She's not guilty. It's not until you get down here where they've proven to you beyond a reasonable doubt that it was not self-defense. That is the only way that you can find her guilty, because the law says so. Now, this is the verdict form, and this is what you're going to see when you go back there to deliberate. And based on all of the facts and evidence, when you get back there and you're deliberating, we're going to ask you to check that box B. The defendant is not guilty. Thank you.
Mr. Buxton, can you, Ms. Sizemore, approach real quick? A very short break, then Mr. Buxman will have his concluding statements to you, and we'll go from there, okay? Very short break, and then we'll have some concluding arguments by Mr. Buxman. Then I will give the jury the rest of the jury instructions, probably 10 minutes or less on that. Then they'll deliberate, okay? I do want to express my thanks to all of you for how you've acted during this trial. It's been wonderful. Everyone has acted completely appropriately, and I really appreciate that. But I want to let you know something that I used to tell people all the time, is that everyone wants their side of the case to win. Everyone does that in a trial. But only one side can win a trial. And that's just the nature of things. Please, whatever the verdict is, whenever it comes back, remember that this is a courtroom. Everyone just remain silent. Ms. Lawrence, you'll remain silent. Everyone in the audience will remain silent. We'll have a few more things to do with the jurors, and then they'll be excused. Then, as far as you're in this courtroom, everyone don't say a word. Please don't express any, depending on whatever side of this you're on, no joy, no anger, no clapping, no nothing, okay? This is a courtroom. You're free to do whatever you guys want outside the courtroom. But in the courtroom, you're not free to do whatever you want. Everyone's got to keep the same perfect behavior we've had already. Again, I really appreciate that. I know that you can keep it up for the very short time we have left. We'll take about 10 minutes, and then we will finish everything up, and the jurors will do their deliberations, okay? Thank you very much. cold here today. You doing a second one, or you doing both? Okay. You guys don't remember the day when the state sometimes was in the middle?
I do.
And then the fence got there.
I'm not old.
Like when you were in county court, you didn't know what was going to happen until you had to like plan both ways. Which really just meant splitting your one closing in two and doing it that way. But let's go back on the record. I see Miss Lorincz is back in the courtroom. And are we ready for the jurors, everybody?
Yes.
Okay. When I finish reading, I will, as I usually do, ask, is there any objection to the instructions as read?
And Judge, there was a couple words that you messed up.
Okay.
So I don't really necessarily want to say that in front of the jury, so you want to just wait until they're taken out?
Tell me now, and I'll reread it.
I don't really think that it's necessary. I just didn't know. Yeah.
Which word? I mean, if you have an objection, I need to address it now, and I'll re-instruct it.
I have no objection.
But if you want me to is it like something?
I think you just said when there was, indoor injury, you said harm, and then you're talking about the capacity, I think you said something different.
You said capability.
But it doesn't matter.
Capabilities as opposed to capacities?
Yeah.
That's highly possible. Where is that in justifiable use of deadly harm?
It's at the end, for the capacities one?
For which one?
Are you asking about the capacities one?
Yeah.
Yeah, it's in justifiable use of deadly force under, when you're talking about the physical capabilities between the two.
So I said capability as opposed to capacity.
Yes, I believe so.
I can reread that if you would like me to.
You reread it, Judge, I don't have an objection.
I mean, they have almost the same definition.
Right.
The state has no objection to it.
Seems like capability is more appropriate anyways, but I don't know what capacity means. But if I said capabilities, if you want me, and I may have, okay, no question. If you want me to reread that, I'm happy to reread it. If you don't want to reread it, let me know.
I don't think you need to reread it.
Okay, so you do not want me to reread it?
Correct.
Okay, so the two words are basically interchangeable, more or less. So if anyone wants me to reread it, I apologize for misreading a word. If anyone wants me to reread it, tell me now. If not, then I'll consider it waived. All right, so I'll consider it waived. And we'll bring it back, and I'll try to make sure I enunciate each word more clearly. The jurors have returned. Mr. Buxman, you ready to proceed? You need the screen?
Yes, sir.
You ready for it now?
Yes, sir. Thank you. I want to start by talking about a few things in the defendant's interview and the testimony of Roy Bedard. And then I want to talk a little bit about reasonableness and eminence. You heard in the defendant's interview, I think on one occasion, there may have been two occasions, in which she indicated that Miss Owens damaged her door in the past? Well, look at the evidence that we have before us. We know the first incident that happened in February of 22, Deputy Coleman came. There was no indication that the defendant reported any damage to her door, showed Deputy Coleman any damage to her door then. We heard about the incident from February of 2023, February, and Deputy Kinsey responded. There was no indication of any damage done to her door. During the interview, the defendant talked about that third incident where she went over across the street into the driveway and confronted Miss Owens about telling a neighbor that she was a crazy bitch. There was no explanation or no discussion about damage to her door at that point. You heard from Dr. Roy Bedard, and ask yourself, what did he add to this case? He's not a psychologist. He's not a psychiatrist. He is not a medical doctor. He spoke in generalities. He told you about various theories. He told you about the structure in the brain and the adrenal glands and how people make decisions and what happens in a stressful situation. His testimony boils down to the more imminent and severe a threat is to someone, and the less time a person has to assess the situation and process the data, the more error that creeps into the decision. I talked with him about the example, if I'm driving down the road, the person ahead of me slams on the brakes, I have to make a split-second decision. Do I slam the brakes? Do I swerve right? Do I swerve left? Or do I just brace? If I have a half second to react to that, the chances of me stopping or avoiding the threat is lower. If I have more time to evaluate and process the situation or assess my surroundings, the chance of me making a reasonable decision and a safe decision goes up. That's common sense. The threat, this perceived threat that the defendant indicated she had that day was not imminent. The threat of somebody banging on a door and yelling a threat was a threat that was coming from the opposite side of a closed, locked, deadbolted metal door. It was not immediate. It was not imminent. It was not about to happen. There was no threat. And the defendant didn't have a split second to make a decision. She had a period of time to make a decision. And she made a variety of decisions during that period of time. And that's kind of what I want to go over in this part of my closing. She told the detectives that she thought the door was going to break in. She thought Miss Owens was going to burst through the door and kill her. We know that the defendant is prone to unreasonable degrees of fear. When she was talking in her interview about the sign throwing incident, she told the detectives, and then when the first time when she threw the things at me, she was just so horrible to me. I was like, I just had neck surgery. And I'm like, she could have really killed me. And I was just like, oh, dear God, she was just violent. She is describing an incident where Miss Owens picked up a no trespassing sign, about 8 by 10, with 2 little prongs that go into the ground, and tossed it at her as she was walking away. Is that reasonable to believe that that act could have reasonably killed the defendant? Of course not. And again, London Remy showed you how it happened, showed you that she tossed it. But she tells the detectives that she's like, Miss Owens could have really killed me. That tells you the reasonableness of her fear. And remember, we're looking at reasonableness through the eyes of an average, ordinary, everyday person. You heard about, and we talked about the incident, the second incident that Deputy Kinsey responded to. And Deputy Kinsey told you that she walked up and talked to the defendant. The defendant's first complaint was about the kids trespassing. And only after that does she explain or say that, oh, Miss Owens said that she was going to drag me out and whip my butt. It's interesting that she never mentions anything about that on the 911 call. She doesn't say, oh my God, I had to shoot through this door, this woman had threatened me in the past. She doesn't say that. She doesn't mention anything about that statement in either of her two interviews, despite talking to the detectives for hours. Ask yourself, how much of a role did that event play in the defendant's decision-making process to fire the gun through that locked, deadbolted metal door? Let's look more closely at the circumstances about what was going on that night and look at her own words to assess how truly afraid and how reasonable her fear was. Her first 911 call.
Yeah, the secretary's out there right now. I'm sitting for my head. I'm very scared.
It's a cell phone video from her phone taken 5 minutes before she makes the 911 call. That's what's causing her fear. That's taken moments before she calls 911. Ask yourself, is that a reasonable fear? That she's in fear for her life? That's not reasonable. So she tells the 911 operator that she is so afraid of these children, she's in fear for her life from these children. Does she run into her house, barricade her house that very moment? No. About 30 or 40 seconds before she calls 911, she's outside taking more video. But she just tells the 911 operator she was in fear of the children. Ask yourself again, is that reasonable? Her actions are completely inconsistent with somebody being in fear for her life from those children. Still the initial 911 call.
They just kept badgering me and badgering me. I'm just sick of these children.
Does that sound like fear of the children, or does that sound like anger?
Are you or anyone else in danger right now?
I locked my doors.
She tells the 911 operator she locks her doors, so there is no danger. Those doors were still locked. That door was still locked and deadbolted when Miss Owens comes over. Now she says she was in such fear of these children, in fear for her life, based on what she told the 911 operator. But there's a chain up there on the door as well. Does she activate that chain? She does not. She doesn't add that third level of security. Why not add that level of security if she was truly in fear for her life from these children? She doesn't do that because she wasn't afraid. She was angry. If she's in such fear of this 9-year-old child, does she take the chair that she says that she places under the doorknob and put it there for added security? No. Because again, she's not in fear of these children. She's angry. She had to walk right by that chair to go to the bathroom, like she said that she was when the pounding and things started. So we know from her interview that when this pounding and yelling began, she was in the bathroom. She hears this pounding and yelling, and she is so afraid, she goes and washes her hands. She tells you that the pounding and yelling stopped. Like it would stop if somebody is banging on the door, come out, and there's a pause for the person inside to come to the door or to react or acknowledge. Then when there is no reaction or no answer to the door, the pounding starts up again and gets louder. That is the complete opposite of somebody who is trying to get into the house. Again, there is no evidence that Ms. Owens was trying to get into the defendant's house. If she wanted to, she had every ability to do so. But she's banging, come out, pause and wait, bang again. And then the gunshot happens. If she wanted to get into the house, why not shatter the sliding glass door? Why not continually bang? Why not throw the body up against the door? None of that happened. We heard from Uriel Rodriguez who said none of that happened. She was banging. And she was banging hard. State never tried to hide that, and I never tried to suggest otherwise. She was banging hard. As we talked earlier in my first closing, that the defendant she is not required legally to retreat because she is in her own home. So in order for her to claim and argue self-defense, she doesn't first have to retreat. But her actions inside the house are relevant to consider the degree of fear, the reasonableness of her actions, and the imminence of this perceived threat. So what do we know? When the banging and yelling starts, she's in the bathroom. This is based on her own words in her interviews. She doesn't shut and lock her bathroom door to put up another barrier between herself and this perceived threat. Instead, she leaves the confines of that additional safe space and walks towards the kitchen, towards the door. Does that sound like someone who is afraid for her life? Of course she's not, because there's a big metal locked deadbolted door standing between her and the knocker and the yeller. In her interview, she admitted that the first words out of Miss Owens' mouth were, "Why do you speak to my children this way?" Not, "I'm going to kill you." I'm going to come into your house. So why do you speak to the children this way? When the yelling starts, she doesn't go find her phone that she had 2 minutes earlier when she just hung up the phone with 911 to call again. Instead, she goes to the bathroom to wash her hands. Ask yourself, how truly, reasonably terrified is she? The banging starts up again and she goes to her bedroom. She grabs the gun from her bedroom, and she doesn't grab the .22, the Ruger, the little plinker that she called it. She grabs the more powerful .380 Remington firearm. She doesn't shut and lock her bedroom door where she is with the gun to put up another barrier between her and this perceived threat in case by some chance, if she truly believes that Ms. Owens is going to come into her house, now she has another barrier to protect her. She doesn't do that. She doesn't walk around the corner and point the gun ready and waiting. No, she doesn't do that. Instead, she leaves the additional safety and security and that additional barrier that she could have put up and walks towards the door. Walks towards this perceived life-threatening threat. She says she walks up to the kitchen table, she raises her firearm, points it at center of mass, where a person would be, and pulls the trigger. One shot. Not a panicked flurry of gunfire. One controlled, precise shot. A kill shot. Ms. Sizemore told you that the defendant, there's evidence that at the time, right before she shot, the defendant said that she heard a crack in the door. You will listen to both interviews and the 911 call. You look at the transcripts. If you want to listen to them again, you have every right as a jury to listen to those interviews again. Nowhere in those interviews does she say anything such as, "I heard the door breaking, I heard the door cracking before I fired." If you want to listen to them again, you have every right to do so. There is no wood splinters on the floor. There's no new damage to the door frame. There's no wood hanging off when the deputies get there and the crime scene investigators examine it. There's no evidence whatsoever to indicate that there was a crack before the gunshot took place. You heard from Josh Wright and Toby Terpstra. They collectively created the diagram as well as the digital animation. And using the diagram created by the defense, before we do that, Catherine Medina, there was discussion about Catherine Medina doing the trajectory analysis and how that she didn't calibrate certain things. Her role was not to do a full-blown trajectory analysis. She's told you she doesn't have the training and the experience to do that. Her goal was to create a general representation of the trajectory. And even Josh Wright said, based on what she did, it may be a little larger cone of error, but her job and what she did and her representation was a good representation of where the defendant would have been in the path of the travel of the trajectory of the bullet. But take the diagram provided by the defense as true. Who fires a gun like this? She's trained. She's gone to the range. She's practiced. I think in her interview, she said she's watched videos of how to properly shoot and things like that. She even demonstrated in her interview that she held the gun like normal people hold the gun. People don't hold the gun over your head like that. That's the representation provided by the defense. That is inaccurate. That's not reasonable. People don't do that. In order for the gun to be brought down lower, she has to advance closer and closer to the door to maintain that trajectory line. Now, ultimately, does it really make much of a difference where the defendant is standing in her house when she fires? Not really. Does it matter if she's standing right by the kitchen table or if she's standing a foot or two up or a foot or two back? Not really. It doesn't change the facts in this case. What's important about where she's standing is, assuming she's even standing where she says she was standing, what's important is, after she gets the gun, she's approaching the door. She's walking towards whatever this life-threatening threat that she thinks there is. She's approaching that threat. That is inconsistent with somebody who is afraid for their life. That's, unless you're a law enforcement officer, or military, or firefighter, most people don't approach the threat. They don't run towards the threat. You heard and saw the video reenactment created by Mr. Terpstra. He admitted that that was based on the defendant's version of events. The video and the way he went about creating it, it was pretty cool. It was neat. But ask yourself, what does it add to this case? It shows Miss Owens banging on the sliding glass door. Well, we know that happened. Gabriel Rodriguez told you that. It shows the defendant, or Miss Owens banging on the outside of the defendant's door. Well, we know that happened too. It showed the defendant walking towards the door with her gun raised and firing a shot through the door. We know that happened. And it showed the shooting of the projectile, the bullet, through that closed door and hitting Miss Owens. We know that happened. Now, he took some artistic liberties by making the mirror shake and the door shake, and he did that on his own. He's basing it on the defendant's interview, but he decided how to make that happen and how to artistically represent that, to represent the degree of force that the defendant said she saw. That's not evidence. That's a representation of his artistic representation of what he thinks the defendant meant and what the defendant said she saw. Again, the video was cool, but it really doesn't add anything to this case. So after the shooting, we hear she makes a second 911 call. And we heard during the first couple minutes of that second 911 call, she's crying. She's upset. Of course she's crying and upset, ladies and gentlemen. She just fired a shot. She knows she shot somebody and realized the gravity and the implications of what her decision was. But notice how her demeanor changes very quickly during that 911 call when she starts talking about the children.
Something keeps trespassing over here. They're bothering me and bothering me. They won't fucking stop. Her boys were here earlier. They keep leaving their garbage all around the house. Okay. And then I told them to take the crap away, get the fuck out of here.
That's after she fires and after the first initial minute or two of her crying. She's still angry on the 911 call. You saw Deputy Barbosa's body-worn camera when they had first made contact with the defendant. That happened right after she hung up with 911. She wasn't hysterical. She wasn't bawling her eyes out. She was calm. She was cool. She was collected. I think she asked to go in and get water and asked for something to be done with the cats. And look at her demeanor within minutes of being placed in the patrol car. She's, again, not crying. She's not hysterical. This goes to the reasonableness of her fear. Deputy Welfenberg described her demeanor as indifferent. As I said earlier, ladies and gentlemen, the law requires the threat of death or great bodily harm to be imminent before deadly force is used. There was no imminence at the time she fired that gun. The word imminent is very important. It's included in the law in the instructions for a very important reason. In order for the defendant to lawfully use deadly force, the threat to her life had to be imminent, had to be ready to happen, had to be staring her in the face such that she had to act at that moment to protect herself. Now, some of the defendant's medical records were introduced, and there's no dispute that she has those medical records and she has some medical conditions. And if this was a situation where Miss Owens broke down the door or broke that sliding glass door and was coming at the defendant, those medical records might be relevant because her physical ability to actually engage in a fight could be relevant to this case. None of that happened. Why? Because there's a big door standing between the two of them that couldn't be breached. The defendant knows what imminent means. You heard in in one of the interviews that she did, she gave an example to the detectives. She said, imminent danger is like when a 4-ton truck is coming straight at you and they are swerving with you as you try to run away. That's a very different situation than somebody banging on the outside of a secure door and yelling with no ability to enter. Ms. Owens is not a 4-ton truck. She was not coming at the defendant when the defendant fired. She was not swerving to try to get to the defendant as the defendant ran away. Ladies and gentlemen, the defendant didn't have a half second to process this. She had minutes to process this. All the decision making that we just went through in the beginning of this part of my closing, all the decisions she made, where she went, wash your hands, go here, walk around here, go to the trash can, grab the more powerful weapon, come and approach the threat and fire. And then she had the presence of mind to go back with the gun she just used to shoot and put it back in the trash can underneath the smaller .22 Ruger. Ladies and gentlemen, as a society, we do not condone shooting another person because of an act that may occur in the future, or because X, Y, and Z may happen, and I may be forced to defend myself. Law enforcement officers are not allowed to go around shooting people because the person may have a gun, may pull it out, may threaten the officer with it.
That's sustained.
The danger has to be imminent. Not, it could happen. It may happen. If 2 or 3 or 4 things occur, it may happen. That's not imminent. The defendant does not get to shoot Miss Owens because Miss Owens may somehow manage to get through that door and may then decide to attack. Because before that door is actually broken in, Miss Owens has no physical ability to cause any harm whatsoever. That is the law that we have agreed to live by. Because there was no imminent danger when the defendant pulled the trigger, her decision to shoot and kill Miss Owens was not reasonable, and it was unlawful. We talked in jury selection that your role in this case is to determine whether or not the defendant's actions on the night of June 2nd, 2023 violated the law. It is not anyone's role here to determine if the defendant is a good or a bad person. And this decision that you're about to make should not be based on sympathy to Miss Owens, her family, sympathy to the defendant. Your decision in this case should be based on the law as the judge reads it to you and how the facts that you know that have been proven apply to that law. And as I said when I started this, the facts really aren't in dispute. Miss Owens is banging on the door yelling. She's angry. She's angry about how the defendant treated her children. Miss Owens is not trying to jiggle the doorknob or break down the sliding glass door, break the window, not trying to get into the house in any way. Law enforcement was on their way. She gets her gun. She fires one shot, center of mass, which kills Miss Owens. The judge will tell you that it's your duty to determine if the defendant is guilty of manslaughter. If you find the defendant guilty, it is his job to determine what the proper punishment or sentence should be, not yours. I submit to you that if you are back in the deliberation room talking about the case and you're thinking, what's going to happen if she is found guilty? You've already made your decision that she is guilty, because that's what the evidence has proven. After you boil down the facts and circumstances, you really have to answer one question, like I said when I started. Following the laws that we have agreed upon, is it okay to shoot through that closed, locked, deadbolted metal door as someone who was banging on it and yelling, but posing no imminent threat? Based on the facts of this case, it's not okay. Based on the law in this case, it's not okay. Just being afraid is not enough. Just her saying she's afraid is not enough. Using that ordinary, average, everyday person standard, you have to ask yourself, were her actions reasonable? Was her decision reasonable? And was that threat imminent? Was it about to happen right now? Ladies and gentlemen, the facts of this case have proven her decision was not reasonable. The decision wasn't made while acting in necessary self-defense. It was not justified. Because of that decision, because of that unlawful decision, Ajike Owens lost her life. We ask you find the defendant guilty of manslaughter with a firearm, because that's what the evidence has proven beyond any reasonable doubt, and that's what the law requires. Thank you.
Ladies and gentlemen, if you listen carefully, have your final instructions, okay? Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You have heard testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusation against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2. Whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. 2. The case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not be Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. Here there is only one crime, so only one verdict may be returned. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It reads as follows. It says right on it, verdict. Count 1, the only count. We, the jury, find as follows as to count 1 of the charge. In parentheses, check only 1 as to this court count. The first choice, A. The defendant is guilty of manslaughter. If you check A, you must then answer the following question. Did the state prove beyond a reasonable doubt that, during the commission of the offense, the defendant personally used a firearm? You'll check either yes or no. The other choice, B. The defendant is not guilty. So say we all, dated, this is the 16th day of August, 2024. This will need to be signed in pen by the foreperson, and the bailiff will have a pen back there for the foreperson to use. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way, and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions, or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. This includes any sort of like Apple Watch or anything else where you can get and send emails or make phone calls. Okay, you'll need to leave that with the bailiff. If you have an old-fashioned watch like me, you're fine. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. A, these exhibits will be sent to the jury room with you when you begin to deliberate. B, if you wish to see any audio or video exhibits, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you don't like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Give me 1 second. Put my stuff together here. At this point, in just a few moments, you're going to go back to the jury room, okay? We'll have your lunch for you shortly. You can either eat lunch and then deliberate, or deliberate through lunch. Choice is yours, okay? The evidence, the physical pieces of evidence that you can physically see and touch and look at, they'll be brought into the jury room for you. Electronic evidence, 911 calls, the recordings of the conversations and the statements, anything that you saw digitally on the screens, you'll need to request to come back out here to watch that, because obviously we have no computers in there for you to watch it. But send me a note, and then we'll bring you out here all together, and we'll all watch it. You can watch it as many times as you want. You can get as close to the screens as you want. The choice is yours, okay? There's no limit on your deliberations. You can take as long or as short as you need to decide this case. The final instructions that I just read, these instructions are for the foreperson. I have put the verdict form on the back of the instructions so it's easy to find. The other 5 copies are for the other 5 jurors. They don't have a verdict form, okay? The reason I said 5 is because 2 of you have been serving as alternates, and the alternates will not go back into deliberation. What's going to happen is you'll still get your lunch, but we'll have you take that in another room, and then I'll discharge you after that, okay? The alternate jurors are, and remember your numbers, juror number 7 and juror number 8. If you're our juror number 7 or number 8, I'm going to ask you, do you have anything left in the jury room? If so, please retrieve it at this time and bring it out here. The rest of you are not alternates. So as soon as they come out, I'll let you go back, okay? And give the bailiffs a few minutes. They'll bring in all the evidence for you. And they'll also bring in the instructions for you. Yeah. If you all would just wait there, the rest of the jurors, you'll go back to deliberate, okay? And we have the instruction for you. what I'm going to do is we'll have your lunch for you in the other room, and then when you're done with your lunch, we'll take care of you being discharged, okay? I'm going to ask you, even though you go home, not to look up anything about this case or discuss anything about this case until the end of the night, okay? Or if you hear the case is over. The reason for that is if something happens to one of these jurors, you could be brought back in to participate in deliberations. So I need to keep you as pristine as you are now, okay? So we'll take jurors number 7, number 8 to the other jury room, give them a lunch, and then you'll be discharged with my thanks. And I do appreciate it. Have a very pleasant day. The jurors have retired from the courtroom. Is there any objection to the instructions that I read?
No.
Did I mess up any words?
No, sir.
There was one error in there about the other trust. It's always one. But we're down to maybe one, so that's maybe progress. All right, so we'll be in recess until we hear something. Thank you all. Y'all want to look at the evidence going back?